Somewhere between 30 and 60% of homes in America are overassessed for property taxes right now, and fewer than 5 in 100 owners ever challenge it. So ask yourself the blunt question: are you quietly overpaying every single year without knowing it? The good news is you have a real, legal right to appeal that number, and homeowners who actually do it win at least a partial reduction the majority of the time. So let's walk through the whole thing. How to read your assessment and catch the errors, exactly how the appeal process works step by step, the evidence that actually moves a board versus the arguments that go nowhere, the strict deadlines that will not bend for you, and when it's finally time to bring in a professional. Let's get one thing straight before anything else. This is not you asking your local government for a favor. Every state built an actual legal process for this, because assessors value thousands of homes at once using mass computer models, and computer models get things wrong square footage, a renovation that never happened, a comp that doesn't match. You're not begging, you're formally disputing a specific number with a process that has rules, deadlines, and a decision maker who has to listen. And don't get thrown by the vocabulary. Texas calls it a protest, Georgia calls it an appeal, and depending on where you live you might see grievance or equalization complaint. Different label, same underlying right. Make them prove the number or watch it move. This flowchart is the whole journey compressed into 6 steps, so let's actually walk it like you're doing it this spring. Step 1. Your notice shows up in the mail, and here's the trap almost everyone falls into. The deadline usually counts from the date the assessor mailed it, not the day it landed in your mailbox. So if you let it sit unopened for 2 weeks, you may have already burned a third of your window. Step 2, you're not reading it for the dollar amount, you're reading it like an inspector, checking whether they've got your square footage right, the right bedroom count, the right lot size, because a data error is the single easiest thing to fix, and it happens constantly with mass computer valuations. Step 3 is where the real work is, pulling recent sales of homes like yours, plus digging up what similar properties nearby are actually assessed at, because a lopsided assessment compared to your neighbors is its own separate argument. Step 4, you file, on time, no exceptions. We'll come back to why that matters so much. Then notice steps 5 and 6 aren't the same thing. 5 is an informal, often just you and a staff appraiser conversation where a lot of cases get resolved on the spot, and only if that doesn't work do you move to 6, an actual hearing in front of a review board. Skip step 5 and you skip your easiest, cheapest shot at a fix. I want to slow way down here, because more good appeals die on this one point than on any argument about value. These deadlines are not suggestions, and in most places, not something a sympathetic clerk can quietly extend for you. Take Texas as the example. The law gives you until May 15th, or 30 days after your notice went out. Whichever lands later miss that. And Texas does allow a late filing only if you can show good cause before the board finalizes its records, which is a real but narrow escape hatch, not a backup plan. Georgia runs on a flat 45 days from the date printed on your notice, and Georgia courts have treated that deadline as what lawyers call jurisdictional, meaning miss it, and there's often no case at all, no matter how right you are. And Cook County, Illinois does something totally different. It doesn't run on a single date. It opens a roughly 30-day appeal window one township at a time, and if you miss your township's window with the assessor, you get a second, roughly 30-day shot at the Board of Review. 3 states, 3 completely different clocks, which is exactly why the very first thing you do with your notice is find your own jurisdiction's actual deadline, not assume it matches what you just heard. Boards see the same weak arguments every single day, so let's talk about what actually lands. Comparable sales are the workhorse. Most guidance points you toward 3 to 5 recent sales of genuinely similar homes, not just a house on my street, because a board can tell the difference between a matched comp and a convenient one. An independent, paid appraisal is heavier artillery, worth the cost mainly on a higher value home or a messy, contested case, because now you've got a licensed professional's opinion instead of just your own. If your house has real problems, a cracked foundation, an outdated roof, water damage, dated photos plus a contractor's written repair estimate turn, this place needs work. into a specific dollar figure a board can actually subtract. And then there's the one people miss entirely: unequal appraisal, sometimes called uniformity. This isn't about what your house is worth. It's about whether you're being valued higher than comparable houses around you. Texas explicitly recognizes it as its own separate protest ground, and Illinois State Appeal Board recognizes it too, though notice it can carry a tougher evidence standard there than a plain market value argument. Bring the right kind of proof, and you're not asking for sympathy anymore. You're handing them a number they have to answer. Run your eye down this table, because it will basically tell you in advance whether your appeal is going to work. Everything in the winning column shares one trait. It argues about the number, and it's provable. My assessed value is too high because these 3 comparable homes sold for less is a claim a board can check against data. Now look at the losing column and really sit with the very first line, because it trips up more people than anything else. My taxes are too high is an argument about your tax rate, the percentage your city or school district charges, and that's set by elected officials at budget time, not by the assessor's office, and not something a property value appeal can touch, no matter how true it feels. Same with "I can't afford this," completely understandable, genuinely sympathetic, and legally irrelevant to what your house is worth. One county's own official guidance says this almost word for word. Appeals exist to fix the assessed value, not the tax bill. So before you walk into that hearing, ask yourself honestly which column your argument actually belongs in. Think of this like packing a case file before you ever set foot in a hearing room, because showing up empty-handed is the single most common way people lose. Start with your own property's record card, literally the document the assessor's office has on file for your house, and read it like you're proofreading someone else's work, because a wrong bedroom count or an extra half bath that doesn't exist is a factual error, and factual errors are the easiest wins in the entire process. Next, if your home genuinely has problems, go photograph them properly. Good light, a date stamp, close-ups on the actual damage, not just a sad wide shot of the house. Then comes the research most people skip: 3 to 5 recent sales of homes that actually resemble yours, not just nearby, but matched on size and age and condition. If the number is large enough or the fight is contentious enough, step 4 is worth the money. A licensed independent appraiser's opinion carries real weight that your own spreadsheet doesn't. And don't skip step 5, because it's the one that surprises people. You can often pull or request the assessor's own assessed values for comparable homes, and if yours is out of line with what they assessed everyone else at, that's their own data working against them. Don't skip past this step to get to the real hearing, because for a lot of homeowners, this quiet conversation is the whole case. Before you ever sit in front of a board, most assessors' offices will let you sit down, or even just email, with the staff appraiser who's actually assigned to your property, and walk them through your evidence directly. It's lower stakes, it's faster, and because you're talking to the person who can just fix the number themselves rather than arguing in front of a panel, a genuinely large share of disputes get resolved right there without ever escalating. Here's the one habit that saves people real grief later. If they agree to a lower number in that conversation, do not just take their word for it and walk away. Get it in writing, because verbal promises have a way of not showing up on your actual tax bill. If the informal conversation doesn't get you where you need to be, this is the next stop, and it's more procedural than dramatic think conference room, not courtroom drama. You'll sit in front of a panel that goes by different names depending on where you live: an appraisal review board in Texas, a board of equalization in Georgia, a board of review in Illinois, and you'll lay out your comps, your photos, your appraisal, whatever you built in that evidence file. Here's the part people don't expect. The assessor's office gets to respond, often with their own comparable sales or their own uniformity data, so you're not presenting into a void, you're presenting into an actual back and forth. The boards that hear these cases do it dozens or hundreds of times a season, so keep your presentation tight and factual. Lead with the evidence, not with how frustrated you are, because frustration doesn't move a number and a clean comparable sale does. A no from the local board is not the final word, and this is exactly where a lot of homeowners quietly give up when they didn't have to. In Texas, you can typically take an unfavorable ARB ruling to binding arbitration, which is faster and cheaper than a courtroom, or you can go straight to the courts. In Georgia, you generally get 30 days after the Board of Equalization's decision to escalate to Superior Court. And yes, that clock is just as real as the first one was. Illinois hands you an actual fork in the road. You can petition the state's Property Tax Appeal Board, which reviews your case fresh, from scratch, with no assumption the local board got it right, or you can file a tax objection in circuit court instead. But you generally have to pick one lane, not both. None of this is cheap or fast the way the informal conversation was, which is exactly why most cases should end well before you ever get here. But it's worth knowing the ladder doesn't just stop at your county's front door. Most losing appeals aren't lost because the homeowner was wrong about being overvalued. They're lost because of a handful of repeat mistakes. The number one is arguing the wrong thing entirely, complaining about the size of the check instead of the number the check is calculated from, which we already covered, and it's still the single most common way people waste a hearing. The second is procedural and brutal. The deadline passes, and in a lot of places, that's simply that Illinois State Appeal Board, for instance, treats its own 30-day filing window as firm, full stop, no extensions. The third is a weak comparison pointing at one neighbor's lower bill instead of building an actual matched set of comparable sales, which a board can wave away in about 10 seconds. And the fourth is just leaving free value on the table. Skipping the informal conversation and marching straight to the formal hearing means you skip the fastest, cheapest chance you had to just get it fixed. There's a real point where doing this yourself stops being the efficient choice. If your home is high value, or your case genuinely hinges on a complicated uniformity argument with a pile of comparable assessed values to organize, a property tax attorney or a professional tax consultant earns their fee fast. The same goes the moment you're escalating past your local board. Arbitration, a state appeal board, or an actual courtroom all have their own procedural rules, and that's a very different skill set than a friendly conversation with a staff appraiser. And honestly, sometimes the reason is just bandwidth. Pulling real comps and building a clean evidence file takes hours you might not have, and a lot of property tax consultants work on contingency, meaning they only get paid out of the savings they actually win you, which lowers the risk of trying. This is general education, not legal or financial advice, so if your case is big or messy, get an actual professional in your state to look at it. So here's what to actually walk away with. First, this is a real right, not a favor you're asking for, and the very first task on your list is finding your own county's actual deadline, because nothing else in this video matters if you miss it. Second, win it the way every provable appeal is won. Matched comparable sales, or an independent appraisal, or dated photos of real defects, or a genuine unequal appraisal comparison. Never just a feeling that the number's too high. Third, don't skip the informal review to get to the real fight. It's often faster, cheaper, and where a huge share of these cases actually get resolved. And last, remember what you're arguing. The assessed value, not the tax bill, and if the local board says no, the ladder keeps going: arbitration, a state board, or the courts, depending on where you live. Do it this way, and you go from someone quietly absorbing an inflated number every year to someone who made the county prove it. This video is general education, not legal or tax advice, and the details that matter most, your filing deadline, which evidence a board will accept, and what happens after a local board says no, vary by your state and even by your county, so always check your own assessor's or appraisal district's website for the exact rules that apply to you. Before you act, pull your own assessment notice, confirm your actual deadline, and if your case is high value or genuinely complicated, talk to a licensed attorney or property tax professional in your state. If this saved you money, subscribe. Homeowner Rights Explained breaks down one homeowner right every video.